So welcome everybody, including those listening by recording. I typed on the board. We will cover questions, highlights, the rest by course messaging. The more questions you have, the better. I will sometimes, though, give you a more fundamental answer than what you truly wanted. You may have wanted a very specific answer applicable only to your home state, and I may end up giving you more of a textbook type generalized answer that leads you into research. That's not because I can't find the answer. It's because intense deep learning involves you getting a general concept from me or a hint or a help and then digging. You learn more about the subsoil by digging than you do by getting told. Yes, yeah, Mr. E. Mr. Eric Martin was my paralegal, and before that he was a legal secretary. I had a number of other employees. I had lots of employees over the years because I practiced law on my own from '81 on. I practiced law for some lawyers that I sometimes call the outlaws, affectionately speaking. I'm on good terms with them, both retired now. Wonderful people, worked for them a year and a half, and then worked for myself from '81 on through 2007. So I had a pretty good run. I never missed a payroll. I always had a savings account, so I didn't have to go to the bank and borrow to make a payroll. And of course, some folks in my area, if you knew my area at the time, you'd say, how the heck did you do that? Because we were not a high income area. But it was interesting, wonderful people who had no money. I managed to help them somehow. And then, of course, I had folks, big farmers, some big business people. They were also wonderful. And one of the farmers who employed a number of people actually paid me a couple of times to help others. I got a kick out of that. So I sort of that was kind of neat as far as doing some of that. And of course, I was not in the economic fix ever that today's lawyers are. We didn't have, I'm old enough, we did not have the student loan difficulty that folks have today. And I had better backing, better family backing. I was a more secure, probably more economically secure than many of today's lawyers. Many of today's new lawyers are not. I did not have that difficulty. It just, I do sympathize with today's new lawyers that are just starting out and doing a wonderful job working for clients. They're fighting for clients, and they're doing the best they can. But they do have an economic challenge, and of course, paralegals can help a lot. Some of those lawyers are trying to do too much on their own, and I've encouraged them to hire folks because you can multiply your efforts if you hire somebody who has your back and proofreads really well. And I guess well, I'll talk about that a little bit. In order to become a lawyer, you take the bar exam after law school. Some folks attend law school without intending to be lawyers. There's very few now because of the cost of it. But in the olden days, some people would attend 1 year of law school. But but in some ways that's not really fair to those that want to become practicing lawyers. So very few do that now. So they attend law school. Then after law school, they take a bar exam. Before law school, they typically, at least up till recently, I don't know if they've recently changed it, but they took something called the LSAT, or lawyer, the pre-admission test for law schools called the LSAT, and basically a test of logic and somewhat of generalized knowledge. Okay, a lot of law school might be mystifying to people because you assume they just drill you on memorized principles of law, and they don't. It's much more about refining and aggressively going after logical skills than it is other things. But of course, in the context of the law, you do learn a lot of law in the process. They call on you, and I was comfortable with that, being a natural kind of a public speaking loudmouth, but a significant number of folks that I attended school with were not comfortable. They were not in their comfort zone answering questions unexpectedly. But it's a good place for people who like to battle things out logically. It was not a very good place at the time I went for folks who like to be deep thinkers and were highly sensitive, like a couple people that had master's degrees in English. They were not kind of like tough-minded enough for that day's law school. I suppose law school is a little more sensitive now than it was. It was not sensitive. Sort of like intellectual boot camp, if that makes any sense. Mr. Olson, do you know the facts of this case or not? No, I do not, Professor. And we didn't have to say, sir, yes, sir. but it was kind of rugged, you know. I found out I was 40 years out of date on the on some aspects of constitutional law, and I wasn't 40 years old. I was, 23? So I managed to be 40 years out of date. But that was the nicest professor that I had that said that. And you have to be willing to be embarrassed in front of other people. And then you wonder, well, why doesn't Kirk do that for paralegals? Being a paralegal should not be about that. You should not be on the firing line. You should be the person. You should be the person who figures out and finds the error in there, and finds the source and cites it correctly and sets things up correctly. A significant amount of your work should not be super hyper high stress. Now, your time limit thing tends to be high stress, but it doesn't have to be. During school, try to put the stress on other people. Am I being unfair about that? The stress is on the opposition and to some extent on the person you work for, because you did the reminders. I need the information. I need you to tell me what to do on Joan's file tomorrow because you wanted it on Monday. Tomorrow is Friday. Your last time to get it to me, to get me my directions, is Friday because I have to get it to you back on Monday. And the court hearing is on Tuesday. And you are the time cop. You give reminders, and then you go home for the day and don't worry about it because you did the reminders. You created a calendar, a physical calendar or an electronic calendar. You prepared what you could with the research. You prepared documents and you put them on somebody else's desk. You are not paid to worry yourself sick, okay? and I'm not saying lawyers should be either. One reason they hired you is, and I'm looking towards the future kind of, but I want them to look back after the year after they hired you and say to themselves, you know, I took a nice vacation. I've taken whole weekends off, and it's just not as tough after I hired Leslie, Annie, Carmen, Cassie, Jessica, Kathy, Matt, Nadine, or Nina. Okay? Their life is easier because they hired you, because you are ridiculously hyper organized and you prepare legal documents for their approval. And you double check and triple check things, but you're organized enough that you don't let it sit over the weekend in your head. Well, because most of the students kind of figure that out on their own, and lots of them already arrive because of their previous careers or their current careers, they're already kind of the organizer, the recognized organizer in the house or at work. What I can do is kind of like give you hints and helps as you go. If you're a ponderer who sometimes ponders too much and then lets things go, yes, you will have to beat that and say, you know, I'm trying to work into a career where I don't get to be the ponderer. Somebody else is the ponderer, and I'm the reminder. I'm the squeaky wheel who says, excuse me, it's Thursday. Yeah. It's Thursday, and the court hearing is Tuesday, and maybe the lawyer will say, yeah, but I got this covered. And you'll say, excuse me, may I see the physical file folder or the state of the electronic file? Just a sec. And you look at it and you say, no, we haven't even talked to this person. Would you like me to set up an appointment or a phone appointment? And you did your job, and then if they don't want to do it, that's their problem, not yours. And I don't mean to be harsh on lawyers. I just mean that when you make a list, if you make a checklist, you say, is this checklist sufficient for this file folder? And they say, okay, well, fine. Do the items on the checklist that you understand and bring to their attention things that are not on the check or that you were not able to do. Finding a statute, researching a wrongful death case. You take a look at these activities and so on. You take a look at all of these items and set the time. Now, these might be more time than you need to spend, but you budget your own time. And as you budget your own time, you're going to find that you can get everything else done. Some stuff you memorize and other stuff you just do. So I want you to max out your 10 points by using a source and doing that starter post with a reply or more than one reply. So you do a starter post and one reply. So you have a schedule of activities, and maybe you want to quickly do 2 posts, even though you say, I don't have time to ponder, then do what you can. Same thing with studying for the quiz. You may not have time to ponder every concept that you've gone over, but just do the best you can. Each week in which we have a project or other written assignment, typically you want to budget more time for that than some of the other items, because this is more your product. Discussion is really interaction plus a source. Quiz, if you're concerned about missing a quiz question, stop doing that. Don't worry so much about that. Rack up your points on the discussion and course project. The quiz is there to help remind you to review. The best thing to learn, and this will help in all of your classes, is to ask these questions instead of the yes/no questions. These are called the journalist's friends. Oh, the survey should already be there. Student survey. There's no student survey on the home page, so where is it? Where is it? I will find it for you. It's not on the home page. I'll see if it's on Module 4. Don't see it. Maybe they took it out. Let's see. Let me try again. Try the home page again. Okay, they didn't put it up, so there's nothing I can do about it. If they didn't put it up, it's not there. It is there? I'm looking at your course. I'm not seeing it. Student survey, it says no available surveys. This is different in your view than mine. I'll try student view. Nope, still not there. So I don't know what happened. This is different in one section than another. I do not see anything in Module 4 or in the home page. Okay, yeah, but student survey is not mandatory. I would minimize time for that. You can certainly do it, but it earns no points. 0 points. What will earn you points over and over again, though, is this. Learn these questions. Can I ask a bad question? We'll start a question with the word were, W-E-R-E. Were you there when Bob and, were you and Bob there when the incident happened? What's wrong with that question? Why doesn't that get much information? Yeah, it's a closed-ended question. I call those mother-in-law questions. My mother-in-law really didn't want to hear my voice, but she sometimes wanted some information, so she would supply all the information. But unfortunately for her, the answer to every one of her questions was just simply no. Well, don't worry about that, but assuming that it's in context, but wouldn't it be better to start with who and say, who was present at, when did this happen, what happened, or what occurred after the car crash. That kind of things. Use the journalist's friends. Who, what, when, where, how, and sometimes why. Some people say you should never ask why, but I think it helps because it brings in the human element. And sometimes listening to a why answer actually gives you some of the what, where, and how. Okay? But start with who, what, when, where, how. And then consider asking why. Sometimes, like I say, it's up to you and the lawyer can decide whether it's good to ask a certain person why. So think about doing a partial checklist. And particularized means you ask follow-up questions. Let's say that it was about a felony matter such as a battery, called in some states of an assault or whatever. Let's say it's a fairly major crime where somebody got injured. You might say, instead of just accepting, yes, there were major injuries, you could particularize it and saying, what injuries did you have to get medical treatment for? So you're still asking a what question rather than a, did you see Dr. Elwood for the treatment? I would rather have you ask what medical injuries did you seek treatment for, and then who gave you treatment. So then you'll get more information. They may have seen 2 or 3 doctors. So just asking them only about Dr. Elwood doesn't help very much. There's no live lecture points this time. I hope that you work on this. If you didn't get federalism correct, think about review what you missed last week. Summons and complaint. If you find a model summons, use it. Some states don't use a summons. They have an application for summons, and the clerk of court issues the summons. And that's where it helps to ask me for help. My state, for no really good reason, usually almost always has us type the summons, and then some things, like an eviction, we didn't type the summons. We turned in the complaint, and then the clerk typed the summons, and then got a signed in ink signature of the judge. I suppose to make it more dramatic. I don't know, but my state has complicated rules, too many different procedures. But there's no use complaining about it. That's one obligation you don't have. You don't have to enter complaints. Just try to get a competitive advantage over other law office employees by learning more about the forms than they know. Some states use an application and then the clerk, or maybe called an admin, issues or types the summons. Yes, use the application if you're in that state, if correct for your state. Absolutely. Yep. You know, if you make an error, but you are learning real world things that you are going to use. Let's say that you were in my state and you did the wrong form, but you did a form that would have been correct for something. You're still giving yourself beginner level skills. You're still going to rack up points for it. It's not, the intro course is not about final knowledge and perfect knowledge. It's about doing a bunch of stuff, partially on your own, partially with coaching, and getting into your state's laws, procedures, forms, okay? Let's just say that we're trying to do things that you would not be doing exactly in the law office, but I'm not trying to make it harder. I'm trying to make it easier so you have time to think about the concepts behind it. In the law office, you will be given the forms, but you will not have time and energy frequently to go into the concepts behind the forms. Nobody's going to sit and tell you what a summons is or answer your questions about summonses and complaints, probably in a law office. Other than if you work for one of my good friends that actually do that. You know, there are certain lawyers that will do that. You have folks that will have a morning meeting with staff people, and they will answer those questions. Those are not dumb questions, but frequently in practice, things are so rushed they will not tell you the concepts behind it. Knowing the concepts behind it, though, will help you do basic tasks like proofreading. If something does not make sense, challenge it, even if you feel embarrassed. So be assertive. If it does not make sense, it still may be right, but try, okay? Try to make it make sense, okay? So if it does not make sense, challenge it. For instance, if you typed up a summons at your lawyer's direction that you're working for, and you were summonsing your own client, I'd like you to challenge that and say, why is our side summoning ourselves? Because the summons is not necessarily saying that they're going to be charged with a crime, but it may be saying that they are going to be sued for money. We typically would not sue ourselves. We typically would not sue somebody else in the same household, with certain very odd exceptions having to do with insurance or something. But if it says that we are suing somebody for money in a summons and complaint, and the defendant appears to be the person that your lawyer is representing, I want you to challenge that and say, did you mean this, or did you want me to do it the other way around, with the client being the plaintiff that is suing for money? Do you see where I'm coming from? So don't be a scaredy cat. Be bold. If they embarrass you and whatever, don't work there anymore. Okay? And I know I'm exaggerating. You say, well, it's Kirk doesn't know how my life is. That's true. But I'm overstating things just to help you remember this, okay? I'm not saying absolutely, oh no, you should quit if they're snotty. Well, lawyers get, a good lawyer may be rude at times, but that doesn't necessarily mean that Kirk is right that you shouldn't work there. You should challenge them in the right way. You should challenge me in the right way. Okay? I'm trying to overstate it enough so that you are assertive, because most paralegal students are not assertive at all. Most paralegal students are very good at details, but they're scared that everybody else is right and they're not, and I want you to stop doing that, okay? And start realizing that you may be right due to common sense, and that you can politely in writing say, I would state that it should perhaps be the other way. You know what I'm saying? You don't have to confront someone and holler at somebody. You don't have to holler at another employee or at a lawyer. You can just say, well, I typed it as you requested, but I did an alternate version that I think is probably correct. I think that there was a mistake here. You don't have to personalize it and say, you were an idiot. You told me to type the wrong name in the wrong place. You don't have to do that. You can just say, would you like this alternate version? I think the client's name is supposed to go in as plaintiff. Okay. Or we don't use addresses on our complaints anymore in our state, or we do. We have to have an address for each party, or we have to have the county as part of the complaint, things like that. You find out what's the truth and assert it a bit, okay? If you're already hyper assertive, then that's different. If you're already kind of hyper assertive, then you need to calm down and say, you know, if I work for a lawyer, I don't own my own store anymore. You know, if you used to run your own store, true, you know, then it goes the other way. You have to say, I have to coach myself a different way. When I went to work since I always sort of ran my own shop, when I applied to be a teacher, what was one of the first things I said? I was talking to a dean that was most of a generation younger than me, and I said, I want you to tell me how you want me to teach. And I tried to convey the message. I'm not one of these arrogant, I was in my 50s. My message that I didn't state in words, but my message was, I'm not one of these arrogant older men that do whatever they want to do instead of what they're supposed to do. I conveyed the message, I'm going to be compliant with the best teaching methods you want me to use, okay? But I was already an assertive person, so I needed to convey the message of compliance. If you are not assertive, you need to convey the message that you will proofread things and try to make sense about them, okay? You won't just proofread for grammar, spelling, and that, and citations. Now, maybe it does make sense, but you didn't understand it, but I still want you to challenge it a bit and ask for it to be explained because you will be a better employee from then on. You'll understand better what's happening. Now, you will have to make up some allegations, but it's a wrongful death case now. And is that civil or criminal? That's civil. Civil, not criminal. What's the difference, do you think, between a civil wrongful death and a criminal case? Based on what happens if the plaintiff wins. And I know Matt knows this, but others that are learning it for the first time, either type it in the chat or just write it down on your notes. Your answer. What do you win if you're the plaintiff and it's a civil case? Punishment or money? Yeah, you're right. Money. Now, if you go to a lawyer and you say civil cases are always about money, the lawyer can come up with exceptions, a number of different exceptions, and that lawyer is not wrong. But in order to memorize what you need to memorize for the introductory course, we are taking it, we're simplifying it, and we're saying money on the one side or punishment on the other. And I can come up with a bunch of different things. I can mess with your heads and tell you about child support cases where we put somebody in jail, not we exactly, the judge did, but there's odd things that sort of seem to cross the bridge but don't, which is called civil contempt in that, and there's other things, you know. But there's still a bright line. Civil is on one side, criminal is on the other. Where it seems to cross the line, it really doesn't. There is an unwritten, well, it's also written, but there's some very sound rules. Don't mess with the judge. Do not buck the judge, okay? If you want to know where it crosses over, don't mess with the judge's order, okay? Child support is very civil, yes. Yeah, it is civil. Child support collection is civil. Some states do have a crime for it, but it's rarely used, and it's an oddity. Normally, you'd use the civil contempt power. Well, yeah, but that is civil. Child custody is a different kind of civil. It's one of the exceptions. Family law does produce a number of exceptions, as does certain types of property law. And you say, well, you're not going to get a money judgment, but I understand that. But there's specialized civil cases that are technically not about money. And you might call those a third category, but basically the civil cases we want to talk about are money judgments, and then the criminal cases, punishment. So I don't want you to think about a murder case, even though the facts may also work for a murder. The same set of facts could result in multiple legal cases. Okay. Use the project rubric. That's similar to that. Create a summons. And again, summons may actually be, you may actually have to do an application. If summons does not work in your state. And then, of course, you have to select a civil court, and you have to do a complaint, but you don't want a form complaint that has to do with auto accidents. We want it to be about wrongful death, not about auto accidents. And a freehand bad one is better than duplicating somebody else's perfect one. Okay. When you're in a law office, you will get forms that are very specific, but I want you to do some of the freehand part of it. That's something you can learn in college, but it's going to be very difficult for you to learn that on the job. On the job, the lawyer will have forms from his or her continuing education programs. We used to have them in a ring binder. Now, of course, they're electronic very often. And you're going to say, well, this is easy. Why did I waste so much time just doing forms? Well, I don't want you to just waste your time in school doing forms. What I'd like you to do is do a freehand bad complaint where you draft some of your own numbered paragraphs. So you say something and you say, well, this doesn't look like formal language that I've seen. I don't care. If you put something in there very simple, like John killed Mary, that resulted in loss of money. We are the relatives. You put in real simple stuff. You are, yes, it may not be as formal as what the lawyer wants, but you have freehanded drafted. Simplifying is not bad. The lawyer is really good at making it into a little bit more legalistic, formal thing. That's not a problem. But basically, if you're a beginner, combining your own freehand drafting with a form that you will use later on in actual practice is very good. What typically students do is the opposite. They will use a form for school that teaches them nothing. And then when they're in practice and the form doesn't quite fit, they're stuck because they didn't ever try doing any freehand drafting. Anybody have an idea what I mean by freehand drafting? It's kind of an awkward old-fashioned term. Just your words. Simplified facts. Or simple facts. It's not simplified, but simply the facts. Someone died. Someone caused it. That cost the next of kin money. They want compensation. You know, and you might say, you might think I'm oversimplifying it, but I'm really not. The more you can explain it to somebody else, the better off you are. Explain it to somebody else. Explain some of these concepts to somebody else. When I was teaching banking and finance, I actually had some of my students do a children's story about bank fraud. The big bad wolf did not have big teeth. He found a sneaky way to steal the money from the little pigs and their bank. And by the time they were done doing a children's story, they thoroughly understood bank fraud, and it was kind of fun. But try to find a way to explain this to who's ever in your house. Explain the difference between civil and criminal, for instance, to somebody who's not terribly interested in it. And explain that a wrongful death case is not exactly a crime, even though it's the same facts. How's that? Explain the difference between federal and state court, for instance. If you can explain it to somebody else, you probably know it very well. It'll give you confidence. Types of law found in research, common law versus enacted. Oh, Nadine has a wonderful idea. Making up songs. And so insurance licenses, I proctored one of those exams years ago, and those are challenging. So you had to learn a lot of things to get an insurance license, Nadine. And well, that's wonderful. But types of law found in research, common law versus enacted. Which two are enacted laws, do you think? In other words, passed by a legislature or a city council. Yep. Statutes, ordinances. Which two are primary? Meaning that they're actual law, not comments or opinions. Actual law to be obeyed. Yep. Okay, you're way ahead. Case law, statutes. This one seems strange. I don't think I really got that until I went to law school, frankly, though I studied a little bit of law in college. But once they get into a situation with a precedent established for all cases in that state, it will fall into place. Which two are secondary and not enforceable? I think A is easy, lawyers' blogs. Again, if I say something in class, that's not enforceable, except, well, I suppose it is in my classroom. But judges don't have to do what I tell them to do, not even if they're 20 years younger than me. I don't have to do it. They're the judge, I'm not. These two are secondary. Appellate court opinions, you can quibble about that a little bit. Some intermediate court of appeals decisions are not considered a precedent, some are. But reporter is not a reporter. These are not like Kirk Olson, Cub reporter for the Washington Times or something. You know, they're bound, nice-looking bound volumes. They're called the Reporter, and they've got many, many volumes. It costs a lot of money to buy an entire Reporter. And basically, it's bound volumes of case law. They use the same terminology or the same codes to know where you're looking, even when it's electronic. And this is just more learning methods. I'm not going to go over that now, but I'm going to stop the recording and just challenge you to work as much as you can, and then contact me in course message. I will be gone part of the weekend, but I will check my texts, and I will check course messaging at least a couple of times during the weekend, okay?